I dropped one footnote to say, we showed the example of ICSID as we talk about adverse inference, because it's very clear within the ICSID rules that the tribunal shall take formal notice. Where if you look at the IBA rules as an example, it's may, it's permissible. And so that's why it's difficult to assess in any given situation what will happen. As Professor Dugal has said, it is discretionary to the tribunal. They have great latitude, as one can appreciate. So it's really difficult then to chart systematic behavior, and where there are items like allocation of cost issues at the end, it's also sometimes difficult to ascertain specifically which element may have triggered that. And so we leave you with that as we think about adverse inferences overall, because there's not a lot of guidance in terms of an affirmative rule. Again, much of this is soft law with the IBA rules, and so it's really just guidance, and we are all developing the practice. But, in closing, what I wanted to say is, in general, I have noted this point. There has been an overall and general criticism within international arbitration about the high cost and the lack of speed. A contributory factor to this, if not the factor, is a focus on the evidentiary process. And it comes out even in 2018, the Queen Mary University of London White and Case survey brought it back to this and said, lack of cost, high cost, lack of speed. We really need to focus in on this. In order to better understand how we're going to improve, we have to understand the process. We need to do a deep dive into the IBA rules, the existing framework that is widely accepted. But we also need to take a deep dive into the Prague rules. As those Prague rules build, as parties start to apply them and tribunals start to apply them, whether it's within the contract or it's by application of the tribunal, we're going to start to understand, where each one posits that it's trying to bridge the clash of cultures. Does it really? Which one is preferred? Time is going to tell. But at least we have these documents to help guide our process. And hopefully, the aspiration is always best practices. So we really invite you to read the rules. They're very clear, they're not exhaustively long, and they provide the framework, if you don't already know them well, to revisit them. And I have to be honest to say, Kabir and I did review them in preparing for this and in general for the matters that we deal with. And it just always serves to be a good reminder, regardless of which rule set you're working with. As an example, IBA or Prague, there's a lot out there and a lot to think about. Professor Dugal, please, I invite you as well with any closing remarks. It has been such a pleasure to be here with you in this brief span on evidence, and we look forward to speaking with you more. Professor Dugal, please.
Thank you very much. As Professor Rangachari said, it's been an honor. Now, evidentiary issues cover such a wide spectrum of issues. We're obviously not going to be able to cover all those issues, but we would like you to consider some of these issues, to look at the IBA rules, to look at the Prague rules further, to think about them in a more thoughtful manner. And we also commend you on your interest in international arbitration, on this fantastic journey, and we look forward to hopefully seeing you in person. With that, thank you very much from me. Professor Rangachari, final words back to you.
Thanks so much, everyone. It's really been a pleasure. We'll see you again soon.
Thank you.